Hello and welcome to Counsel about Councils. My name is Irene Parker and I'm the Engagement, Education and Prevention Manager at the Victorian Ombudsman. A bit of housekeeping. This webinar is being recorded, which means a transcript will be available at the close of webinar. Please keep a device with a camera handy. We'll be sharing a QR code at the end of the webinar for your feedback. If you'd like to ask a question, you're more than welcome. However, if you'd like to remain anonymous whilst doing so, you'll need to opt for anonymity on the Q&A function. We'll start today by acknowledging the traditional custodians of country throughout Victoria, by acknowledging their connections to land, to sea, community and to culture. Welcome to you all as we beam in from the traditional lands of the Wurundjeri during this Reconciliation Week. Obviously, integrity begins at home. But when we talk about oversight of integrity in the local government sector, we talk about IBAC, the Ombudsman, and the Local Government Inspectorate. However, for councils, I can imagine that being subject to three watchdogs, each with different powers and functions, might at times feel like facing our three-headed gatekeeper Cerberus. So to avoid the gates of integrity confusion hell, we're presenting this webinar to offer counsel about councils, to demystify how these agencies work and how councils can navigate their way to integrity and enlightenment. To navigate us through this system, I'll introduce a few scenarios to our panellists and they'll take us on a complaint journey that's not always linear and show us who deals with what, why, when and how. With that, let's meet our panellists. But for those of you who are expecting Megan Philpott, Megan is a last-minute apology. In her stead, we welcome Andrew Addison. Andrew is the Assistant Ombudsman and has worked with the Victorian Ombudsman since 2015. Andrew leads the Ombudsman Policy and Executive Office. David Wolf is a Deputy IBAC Commissioner and joined the organisation in 2020. Before that, he was Victoria's inaugural Chief Municipal Inspector and Head of the Local Government Inspectorate. Michael Stefanovic is the current Chief Municipal Inspector and has held that role since 2021. Thank you for joining us and welcome to you all. So as mentioned, we'll be running a few scenarios by you. Let's kick off with our first one. And Andrew, I'll start with you. So a person working in a regional council has contacted the Ombudsman because in the course of their work, they discovered that one of their councillors has been involved in engaging their brother-in-law to complete some $400,000 of works for the council. They know it isn't right. What should they do?
Thanks, Irene. I think I might start briefly, if I may, with a broad overview of the Ombudsman's office and the role that we have, particularly in the local government space. So the Ombudsman can deal with complaints about more than 1,000 bodies. Complaints about local councils make up about 25% of our workload. Each year we deal with about 18,000 complaints. So it's a high volume, fast turnover environment. And our focus is often on trying to resolve complaints quickly and informally. So most matters don't go to formal investigation, for example. We try and get a practical resolution, a practical outcome or a material improvement to fix the problem at hand. So that could be by calling the council, if the complaint is about a council, to try and resolve the issue and come up with a solution. We can also conciliate complaints, which is a relatively new function, but particularly important, I think, when there's an ongoing relationship between the agency and the person making a complaint, as often happens with ratepayers and local government. In addition to sort of our general jurisdiction for complaint handling, we do have a role in the public interest disclosure, public interest complaint whistleblower scheme. So PIDS and PICS, death by acronym maybe today. And this scenario that you've talked through is instantly sending me PID signals that it may involve an allegation of improper conduct. Possibly a breach of Council Code of Conduct, possibly a breach of the Local Government Act. So if we were to receive a complaint of that nature, that's what the officers would be thinking as soon as the complaint came in. Okay, this sounds like it's a whistleblower type matter. This sounds like it's a PID. It'd be sent to our investigations team to form that assessment and decide whether or not it needs to be sent on to IBAC as the clearinghouse for all of these sorts of matters. And I know that we'll get to this in a second. I think that, one, it's great that the council worker raised the issue. They've seen something that they know is not right and they've come forward. And I'd say that there is, obviously they've come forward to the Ombudsman. That is an option that they certainly have available to them. There are internal options and external options. You could go to your manager, you could go to, people might go to the head of HR, they might go to the CEO of the council, all internal options. External options, there are a number of bodies as represented on the board, on the panel here today, but I think the important point is it's a sort of a no wrong door approach, and the system really wants to encourage disclosures coming forward with significant issues that can impact the organisation as a whole or even the sector as a whole. So excellent that the person came forward. The system might seem complicated, but we'll navigate that on the back end and make sure that the right organisation is dealing with the right allegations at the right time. So this particular scenario, allegation about a council law. Council laws, not within our general jurisdiction, but certainly are in our whistleblower jurisdiction. So we would most likely refer the complaint, take the details from the disclosure and refer the complaint to IBAC for assessment.
So David, the person has contacted IBAC. What if they contact IBAC, they write to IBAC anonymously? What happens then?
Well, firstly, thanks for that very colourful opening. Very much appreciated. And thanks for everybody for tuning in. I think it's really important that you get to hear from the agencies in this sort of environment. We can run through these scenarios. And following on a point that Andrew made, a really important point, our research tells us that most employees will report improper conduct to their direct line supervisor. So it's really important that agencies have an awareness of what to do with those reports, where to take them, and in this case, quite a serious matter, to find the right agency to deal with it. But really important to know that most often the report will be made internally. That said, we, as part of the integrity system, we receive complaints from the general public and also referrals from fellow integrity agencies. And that's one of our functions as part of the integrity system. So if I just touch on what IBAC's role is, firstly, we're the anti-corruption agency for the state of Victoria. We have a really broad jurisdiction, which includes police, the public sector, departments, agencies, the judiciary, hospitals, schools, etc., and local government. That's one of our key jurisdictions. Our role as an anti-corruption agency is to investigate, expose and prevent corruption and police misconduct in our jurisdictional area. As part of that function, we receive complaints around all those areas and assess that material to inform what the next steps might be. We have an investigative function, of course, but our threshold to investigate is really quite high. It includes serious and systemic corrupt conduct. Falling below that, there is the allegations of improper conduct, which fall under the jurisdiction of the Public Interest Disclosure Act, the PID Act, for which we are custodians of that Act. So we are responsible for the management of the Public Interest Disclosure Act. So in this scenario, the complaint coming to us anonymously, we would assess that complaint under our jurisdiction, and if it weren't to meet our corrupt conduct definition, we would assess it under the improper conduct definition under the PID Act and determine the best place to refer that matter. And in this instance, an allegation about a counsellor perhaps having a conflict of interest or misusing their position would be a matter that would fit squarely within the jurisdiction of Michael's office. And in this case, we would refer it to Michael's office. Also noting that a public interest disclosure can be made anonymously, and there's some good reasons that exist in the legislation for that.
Andrew mentioned before that IBAC is a clearinghouse when it comes to allegations of improper conduct. What does that mean, and what does IBAC do?
Yeah, really important. So when IBAC was established, it was envisaged that IBAC would be that clearinghouse, so a central point to receive complaints about public sector corruption and improper conduct. And that means that we can use all the material we receive to build a picture about risks to the various agencies or across the sector in Victoria. Noting that the bulk of the allegations or complaints we receive result in the matter being dismissed because the information in the allegations don't substantiate either corrupt or improper conduct, or there may be other reasons why it's dismissed, but we use the intelligence out of that to build a picture. And there's also the matters we actually assess to be referred to other agencies, which again builds that bigger picture around the risk that might be prevailing. And that allows us then to manage the flow of complaints to the various agencies and also have oversight over outcomes, which may then go to contribute to our prevention function, which is at the back end of all of the investigations.
So, Michael, David has sent you the public interest complaint. What would the local government inspectorate then do?
Well, first of all, thanks for having me to this webinar today. It's great to be here with our partners in oversight of the sector. This is a very frequent occurrence. You know, we meet at least once a month, probably more often if there's other needs arise or we have to discuss something. But we typically get our heads together on many things. Now, with respect to our role, we're the lead agency for examining, investigating and prosecuting offences under or breaches of the Local Government Act. And that includes election offences as well. As we're leading into the election season now, we expect to get a few more of those. But in a classic scenario like this, my shop has two sides. We have a reactive side that does investigations. We also have a more proactive side. This would come into the investigative side. We would, although it's been through the IBAC process and triage there, we would look at it as well to work out what pieces of the Local Government Act might be affected by it. We would assign investigators to it. We would look at, our focus is primarily on councillors and senior council staff, but it may also extend in a pick or a pit situation down to other council staff as well. So we would look at what are the relevant provisions in the Act to councillors, what are the potential, we may already, as we're starting to investigate it, be starting to think about, is this a suitable case that perhaps could be dealt with by councils through code of conduct matters and things. We'd certainly had that operating in the back of our minds as we did it, but looking at the fact pattern as it's been described, I'd say this is one of these matters that we would certainly keep for ourselves. We would investigate it. Usually the way we approach council, we do have coercive powers like Ombudsman and IBAC, but typically we get tremendous cooperation from the sector. So we would just reach out to the CEO, governance manager, and we would start to assemble the materials we need to investigate it. And a point would come where we'd get the parties in. And interestingly, though, we don't actually have the power in many cases to actually report on, publicly on the outcome of these cases. So, we may finalise the case, we may make recommendations to council, and including potentially to invoke a code of conduct, councillor conduct panel, but it may not necessarily be seen in the outside world because we can't publish it. So it may appear to the outsider that there's not much happening, but there's a lot. It's like a duck swimming on a lake, feet are working under the surface. So we would be working with the councillors, the council to make sure that appropriate remedies are put in place. We'd focus not just on the staff involved or councils involved, but also look at the systemic issues. Were things about the governance rules that perhaps could have been tightened as well? Council code of conduct matters are always difficult. So are there things around the framework that should be potentially improved? So we'd look at the facts of the matter, but we'd also look at those broader systemic issues as well.
So this scenario is highly suggestive of a conflict of interest. Is all conflict of interest bad?
Not necessarily. We've all got conflicts in everything we do. And it's just, I think, an important thing in this context of local government is initially having the educational training to understand and recognise that a conflict exists. And then under the Local Government Act, for councillors in particular, it does specify what is a general conflict. It gives some examples, same as material conflicts. You really need to get the act out and have a look at if you're confronted with a situation. Do I fall under general? Do I fall under material? And then you have to look at your internal counsellor code of conduct and governance rules as to what are you required to do in your local situation to actually disclose that, come up with a management plan. It may be something that, because of the nature of the conflict, it may be you may just have to step back entirely from any decision making with respect to the issue that's been raised as a conflict. But no, back to your point, no, we've all got conflicts. Identify them, disclose them, manage them, or withdraw.
You mentioned earlier.
Well,
Please, David.
it's interesting that the Local Government Act actually anticipates the conflicts because of the virtue of the fact that councillors are drawn from the community or have significant links to the community, whether that be private interests or business interests. So it envisages those conflicts are going to arise and sets out a framework for which they're going to be dealt with to enable, in some instances, councillors to continue to participate, even if a conflict is present. And that's one of the challenges with local government, is that a lot of complaints arise around a perception around a conflict where, in fact, the legislation permits that councillor to continue to participate in a particular matter, even though a conflict may be present. So it's really interesting. But go to Michael's point that the key thing around conflicts of interest is firstly identifying, it's then recording and appropriately managing. And in the absence of that, if that's not done properly, then there's that gap that's filled by a perception that something is not right and hasn't been dealt with properly.
You've both now mentioned the Local Government Act of 2020, and Michael, you mentioned before that you carry that with you everywhere you go, and in fact you've got that right by your side. I'm curious to know how regional councils respond though, and you've talked about management, but where there are examples of limited options for procurement, for recruitment, how would you specify management of that potential conflict?
Yeah, that's a really important point. Like, and with regional councils, like, not only do they perform all the functions we know of in metro councils, but, you know, regional councils often have the real burden of dealing with natural disasters, the consequences of natural disasters, fire, flood, windstorms and the like. They have to deal with those with limited resources. There's, in some of the council areas, they're very remote. There aren't a lot of providers there, so there's not a lot of competition to start with. Certainly when a big major event occurs in a region, it'll go across council borders. So everyone's trying to compete for, you know, very scarce resources. So there are, councils do have relationships with those primary vendors there to get access to those resources. There's also, at a state level, you've got Procurement Australia that operates as well to provide access to groups of vendors that are experienced in the sector, and they can provide guidance around making sure you comply with procurement rules, other funding rules. But I think it's just knowing that those things will happen, that working cooperatively with your neighbouring council, not competing against them and offering inducements and the like to make sure your roads, bridges, highway are fixed first. But yeah, just being aware of the need to sort of be transparent in what you do.
And in some respects, it's even more challenging in regional areas because the community is generally aware of the interests the councillor holds. And so it's much more visible in terms of the perception of a conflict. So we see a lot of material come through that really, it's community members specifying, you know, the actual membership a councillor might have or the land ownership the councillor might have, and drawing our attention to a potential conflict of interest. Whereas in larger metropolitan areas, it's much less visible.
Let's move on to the next scenario. Andrew, in one of the hundreds of calls the Ombudsman's office gets every day, someone complains about at the council's corporate services director. They've hired a friend and former colleague without going through a proper recruitment process. The Ombudsman is a receiving entity, isn't it? What does that mean, and what would you do with a complaint?
So the Ombudsman is a receiving entity which is under the public interest disclosure regime. So it means that we can receive allegations of improper conduct and will conduct an assessment and decide whether it meets a threshold for referral onto IBAC. In many cases, a person might call the Ombudsman's office and they might have a list of complaints about an agency or a group of agencies. And some might, like this scenario, trigger an assessment under the public interest disclosure regime. And some within the same complaint might be dealt with informally. So our officers here are very skilled at sort of dividing up the issues and allegations that are being raised and managing the process for each as required by the legislation. So for a potential public interest disclosure, I think as mentioned in the first scenario, we'll transfer that to our investigations teams who have a key role in conducting this assessment. They've got 28 days under the legislation from receiving the potential disclosure to decide whether or not it meets a threshold to be sent over to IBAC. So effectively, what we're looking at is does the allegation potentially show or tend to show improper conduct or detrimental action? And if it does, we're required to send it over to IBAC for their assessment as to whether or not it is a public interest complaint.
Okay, so IBAC receive the disclosure from the Ombudsman. They decide that it is a public interest complaint, but you refer it back to the Ombudsman to investigate. So, Andrew, do you have to investigate the public interest complaint just because IBAC sends it back to you?
Perhaps I'll just jump in and talk about some of the provisions of the Act that are engaged at this point. So once your office receive the complaint and make the assessment that it's a public interest disclosure, at that point, some of the protections of the Act are engaged. And that's really important to understand. Those protections include protection against defamatory action, some confidentiality provisions, and protection against detrimental action. So I think it's really important at that point, those protections are engaged. When it then comes to us, we'll do our assessment of it, and more than likely, on the basis of what Andrew's office has done, we'll determine it to be a public interest complaint, which adds another layer of protections to the complaint, particularly around confidentiality, and we'll refer it back for investigation.
And a lot of, within that initial assessment, when it's sort of we're deciding is it going to go over to IBAC or not, I mean, we always have to remember there's a person on the end of the phone there that's making a disclosure of something that they think is really wrong that they've observed. So there's a really important element of witness management, witness welfare considerations as well, and being able to explain what those protections are and when they kick in and what they can expect and not expect throughout the process is kind of an important part of it as well. So yes, it's not uncommon for matters to go between our offices, sort of all three offices as well, but there's I guess a lot of effort is put into ensuring the person who's brought their concerns forward knows where they stand and knows where the process is up to. But yes, many public interest complaints come back to the Ombudsman for investigation. What we do first when we first receive a PIC now, it's a public interest complaint, is we can make inquiries. So it's an informal inquiry with an E, which allows us to really for the first time start testing the allegation. So we can make discrete contact with the council perhaps to obtain some records. In this case, we might look for the recruitment file notes around the decision to employ the particular person. And what we're doing is we're trying to decide, it's a threshold question, whether or not the allegation or the information shows or tends to show improper conduct. Because our Act says that the Ombudsman must not investigate a public interest complaint unless she's reasonably satisfied that it shows or tends to show improper conduct. So it's a proportionality mechanism within the Ombudsman Act that ensures that when we commence a formal investigation, which is a significant process, it gives us access to significant powers to compel the production of documents, to compel witnesses to appear before us, to issue confidentiality notices. It's a serious thing. Being able to conduct inquiries first and do a bit of a test on the allegation and having that requirement that we don't investigate unless we're satisfied it shows something really is important to ensure that we're exercising our powers judiciously, and being very careful about what matters we take on and what matters we don't take on. So that assessment phase is crucial, and it can involve a significant amount of work, but it's really important to make sure that we're only really formally investigating those matters that warrant formal investigation.
So
perhaps if I just jump in there too, sorry, Andrew, is that process does take time. So the investment in the assessment process to make sure that the provisions of the legislation are being appropriately met, and to elicit that additional information can take time. And I think that it's important to note that not every complaint or disclosure has to be considered a public interest disclosure or public interest complaint. There are options for complainant in that 28-day period to, in writing, pull out of the scheme. And that, in effect, allows often the complaint in some circumstances to be handled at the local level by the actual agency, and sometimes much more swiftly. So if there's no concerns about perhaps consequences for the person raising the issue, there are occasions when it's expedient to have it dealt with by the agency itself. So there are some nuances to the actual way a disclosure and complaint is treated.
So in the course of your inquiries with an E, and you meet with the council CEO, and they're equally concerned about those allegations, but they ask if they can deal with the matter themselves and conduct their own internal investigation. How does that sit with you? How does that sound?
Look, I think that from our office's perspective, it's on a case-by-case basis, but as a matter of principle, I would say that it is a positive thing for agencies and councils to want to get their house in order, and want to address their own issues about problems going on within their organisation. So I wouldn't say, so we may very well say that's an entirely appropriate thing to do, as long as the protections remain in place and there's the required level of confidentiality and rigour around the process. The Ombudsman, certainly in the past, has allowed an agency to conduct its own internal investigation of the allegations before we actively investigate. We might be investigating, the investigation might be on foot, but we're sort of suspending our investigative activity to allow the council to deal with the issue first. We can monitor the progress of that investigation, review the outcome of an investigation, and decide, well, is there something that we need to pick up now? Are we satisfied that the issue has been dealt with appropriately? So there is an element of flexibility and an ability to, I guess, constructively address quite significant issues with the council and our office. So it certainly does happen.
David, question for you. The councils investigated the conduct of the Corporate Services Director themselves, and they say, look, we were about to finalise our investigation, substantiate those allegations, but the Corporate Services Director quit. So we're just going to let sleeping dogs lie. Is that okay with you?
I've got to say that that's not an uncommon scenario. Certainly when I started in the integrity space, it was a lot more common. I'm pleased to say that the instances of that occurring are less and less, which is really important. And it's really important for three reasons. And firstly, it's very important that matters are fully investigated to understand not only the level of impropriety or offending, but also what are the vulnerabilities within the organisation that allowed the improper conduct to occur. Because if you don't fix those over time, then you'll see reoccurrence after reoccurrence. It's incredibly important for the organisation to see that there's been an outcome to the investigation as well, not only for the discloser or the complainant, but for the other employees that are aware of the impropriety. If it's seen that there are no consequences, that creates a really negative culture within the workplace. And the final point, and probably one of the most important points, is that there ought to be a consequence for the person that's acted improperly. So let the system deal with it from a conduct or a misconduct or even a criminal perspective. But it's important that's followed through, because we've seen time and time again where it hasn't happened, an employee has popped up in a like organisation, and in local government, particularly where You can move for a time there, you can move around the state almost anonymously, pop up in another council, and we've seen the repeated behaviour. So I think it's incredibly important that the investigations are followed through with a proper outcome. You might be investing in something where it's difficult to justify because the employee is gone, but you're investing around the integrity of the entire sector.
Let's jump to scenario number 3 and Michael. You're investigating a PIC, a public interest complaint from IBAC, and at first it appears to relate to misconduct. But as you're digging, you uncover evidence that makes you suspect serious corruption. What do you do?
I don't have a lot of choice. So, strictly speaking, I have to report it to IBAC for them to assess it. But we would also, obviously, it's not in a vacuum. We would see, as we make the referral to IBAC, there's probably a likelihood that some of the elements that go to IBAC, even if they keep the corruption aspect, there's things that may come back to us. So we may, in our meetings with IBAC, say, look, there's a potential here to carve out material that we can retain, so it takes the load off IBAC. But our primary concern is not denying IBAC the ability to use their powers in the way they choose. So we really, it's that deconfliction. They have primacy for the corruption related matters. So we're guided by what IBAC does with it. I think technically under the law, hasn't happened yet, David, but I think if you were busy and it wasn't a systemic corruption case, potentially you could refer that back to us. So while I did say earlier in the webinar that our primary concern is the Local Government Act, we can actually charge under the Crimes Act as well. So people may not be aware of that. It has happened, but in this bribery space, corruption space, potentially David Shock may certainly retains the ability to refer it back to us.
On that note, so some of the offences under the Local Government Act are qualifying offences for corrupt conduct, so absolutely right, we can refer it to you. But your key point, and I think Andrew raised it before as well, there's often conversations between our organisations around complaints, the disposition of those complaints, the tracking of the investigations, what might be likely. It's also not uncommon for us to be investigating at a particular place an element, and for Michael's office to be investigating another range of issues that might be linked but not closely linked, and that allows our investigation to be narrow and a lot quicker than what it would be if we're looking at quite a range and a net. And likewise, our Office of the Victorian Ombudsman and IBAC have conducted previously joint investigations before under the auspices of our Act as well. So I think the message there is that we are an integrity system. There are a lot of, to the extent possible, conversations around matters to ensure that the best place and the best resources are investigating the appropriate matters.
Let's go back to this question of corruption. What exactly is it?
Well, fortunately, it's defined. So in the IBAC Act, there's a definition of what corrupt conduct is. And in broad terms, it can constitute a criminal offence like bribery, secret commissions or misconduct in public office. And there's a range of other elements to it as well. That's the first trigger for us in terms of looking at a matter that we might consider investigating is, does it meet the definition of corrupt conduct? And then is it serious and systemic? So is it a matter that's going to have broad effect across an agency or a sector and engages our jurisdiction and justifies our resources being applied to investigate the matter? And in talking about our resources, it's important to note that, like all anti-corruption commissions, we have quite wide-ranging powers. Some of those are quite intrusive powers where we can investigate details of what a person's been doing, who they've been meeting, their backgrounds, etc. And it's important to have those powers to investigate the really serious matters that we're often engaged in. We also make sure that when we do use those powers, it is appropriate, it is reasonable. We do it in the context of what human rights we are breaching and whether it is justifiable in the circumstances, to make sure that we are not overreaching in terms of the investigation. And again, important to note that there is an oversight body for our work and for the Ombudsman's work, in particular when we're using our coercive powers, and that's the Victorian Inspectorate, who has a key role in ensuring the interests of the community are protected in terms of the way the integrity agencies are operating.
You're also able to conduct public hearings.
Yes.
How do you decide whether to take this step?
So public hearings are the most powerful tool an anti-corruption agency has in terms of investigation. And the reason I say that is it's the most intrusive. It exposes the witnesses to public viewing of the allegations and material that we're putting to them. And in effect, it has a serious effect on potentially witnesses and the conduct of the investigation. It is an important tool to have, though, I've got to say, but there are legislative requirements we must meet before a public examination is conducted. And as I said, it's generally around the seriousness of the matter, the complexity of the matter, the strength of the evidence. But importantly, that criteria talks about the welfare of the witness and the reputation of the witness to ensure that both of those are not unduly damaged through the course of the public examination. But as I said, it's a really appropriate tool for the right set of circumstances to meet our exposure, so our investigation and exposure of corrupt conduct remit.
So talking of exposure, you've got that capacity to conduct public hearings. What about to publicise or not? The Ombudsman and Local Government Inspectorate can also make their findings public in reports to Parliament. How do you decide which matters stay private and what matters go public? Michael, let's start with you.
Yeah, not quite as simple as that with respect to our office. We only have a very limited number of occasions where we can actually produce a report. Unlike IBAC and Ombudsman, we're seeking change at this point in time so we can table reports in Parliament. But it's again, because we're such a small office, we don't really have we can't invest a lot of resources in some of the critical assessments that need to be made before you decide to put something out. So if we decide to create a report, we want to put it out in the public space, we need to seek legal advice either from the Office of the General Counsel within the Department of Justice, where we're situated at the moment, or engage the Government Solicitor's Office as one of their clients. So that's how we have to deal with it. The legal landscape is changing tremendously all the time. I think IBAC's been challenged a number of times in recent years. Our counterparts in other states have also been challenged on the very ability to even publish reports. Queensland CMC, CCCCC, they had a recent decision as well. But it is a complicated space. I'd like it to be clearer for us that we do have the power to table it. And then I would expect that with that power, they've also provided a prescription as to what we can take, rather than having to go back and get legal advice each and every time.
For the Ombudsman, sir?
We do have an express power to be able to table reports in Parliament related to the Ombudsman's functions. So it's quite a broad discretion. Within the process, I guess, for tabling a report, though, there is, of course, a procedural fairness process that you must go through. If there's any adverse comment or opinion about a person in a report, they need a fair chance to be able to respond to that adverse material and have their response fairly set out in the report. So there are a number of steps that are taken even before you can get to possibly laying a report before Parliament. It's always a case-by-case conversation for our office as well. Ultimately, the decision sits with the Ombudsman. But the sorts of things that we'll take into account will be, much like David and IBAC in terms of a public hearing, you want to think about the impact on the parties involved, of course. There's an element of witness welfare. There's an element of reputation. Equally, though, and balancing maybe with that, there's public interest considerations in publicising the findings from the investigation. So you might have an investigation that was about a specific public officer or a specific entity like a council, but there's a broader lesson there for all 79, or there's a broader lesson there for the public sector as a whole. And so there can be a real benefit in laying those findings before Parliament. And then once the findings or the investigation is in the public domain, it then allows us as well to leverage those lessons in other sort of preventative work. So we can talk about the findings of the investigation in our training, or we might reference some of the lessons in guidance material, or we can come up with other products to help improve public administration. But broadly, public interest considerations about whether or not we table reports in Parliament.
Does that differ for IBAC, David?
Very, very similar for us. Our legislation sets out the process and circumstances for when we can table a report in Parliament, so effectively publish a report. But it is very important that that provision is there, because the work we do often requires that publicity or the public airing to ensure that the preventative function that we're required to do is met. To conduct an investigation and keep it completely in-house really doesn't help the rest of the sector, and particularly if we're talking about councils, the others, potentially 78 councils, from learning from the issue that we're dealing with. And in saying that, in tabling a report, there are a number of options available in terms of naming parties and the circumstances that are actually set out in the report. There are options to produce reports that purely focus with the research and policy issue or a vulnerability issue and really minimise the impact on individual parties. But that said, the most powerful report is one that sets out the wrongdoing, those that have done wrong, and the vulnerabilities that were exposed in the actual matter itself.
You mentioned preventative functions. What about preventative work? How can your agencies help councils to navigate integrity and prevent issues from rising?
So prevention being one of our key pillars and our responsibilities under the legislation is incredibly important to us. There's a number of tools that we use in the prevention space. It could look like research work. We've recently conducted a survey across the local government sector around perceptions of corruption. That we did it last year, and the material from that was really informative, particularly for local government employees and councillors, around where perceived corruption might exist. And then we align that with our other research and, of course, our hard data from investigative material. We produce a lot of information out of our investigative work and research work. That might look like an informational fact sheet or material that we're providing directly to entities themselves. Engagement activity like this is, again, another really important piece of the puzzle. We invest quite heavily in speaking to a particular audience, and right now we're in quite a heavy suite of engagement activities for local government, given the lead up to the local government elections. We're in that really important cycle of the council term. And just as we're talking about the publication of actual investigation reports, whether that be in private, which we do, so there might be some outcomes that we deliver privately, but more importantly, those public reports which really drive home the work we do and the importance of integrity across the landscape.
Michael, what about your agency?
Being such a small agency, there's a limit to what we can achieve. We're not expressly mandated to have a preventive or education outcome. But having said that, it's pretty pointless doing the investigations that we do without being able to pass on some recommendations and the like. So typically we'll do private reports or on occasion public report. But one of our key tools is the fact sheets that we've really started in the last few years. When we have things, major events such as the elections, like we'll put out a summary of what happened during the course of the election, the trends that we observed in particular time. We'll try and put those out when and where we can. And at the moment, we're also on our organisation chart, as I said earlier, we've got a reactive side and a proactive side. On the proactive side, we look at governance and other areas of operations of council. At the moment, we're conducting a major review into the councillor conduct framework, so across the sector, with a view to looking at how that may be improved to make it sort of more timely and delivering on better outcomes for all of the stakeholders. So it's a major piece of work we hope to have in the short term. So again, because of issues around publishing and potentially things coming back to individuals, we have to be extremely careful about what we publish. So the work's being done, and there's just a lot of time is spent on making sure we don't breach, damage anyone's reputation and the like when we produce these things. So, but yes, we realise that despite not necessarily having a mandate or a budget for it, we have to get something out so people understand what it is we do. And if we see something people can learn from, we need to find a way to get it out there.
Those fact sheets you just mentioned, are they available on your website?
They are, yes.
So your office is not mandated. What about the Victorian Ombudsman's office?
We do have a legislative function around education and prevention as well. It's one relatively new, 2020, came into our Act, but we've been doing work in that space before the function came in. Actually, when when our new ombudsman commenced some 6 days ago, one of the first things she said to me was, you can't investigate your way out of maladministration or corruption. And the point being, I think, that we're an agency of 110, 120 people overseeing a sector of more than 1,000 bodies and however many public officials, hundreds of thousands public officials. We can't investigate everything, and there is a real benefit in the preventative and educational work of these types of institutions. So, look, we offer training, as you know, Irene, for public sector and local government entities around effectively dealing with complaints, good complaint handling, good administrative decision making, responding to challenging behaviour, and managing conflicts of interest. So they're workshop style sessions that people can sign up to participate in. We offer guidance as well. So we have guides on our website. We have a guide about effective complaint handling in local government specifically on our website, and we're about to release a broader one for the public sector, an updated good complaint handling guide. So there are a number of resources that we like to draw on the lessons from our complaints and investigations and turn it into some product that will assist people. One of our objectives in our legislation is around improving public administration. And yes, we do that by resolving complaints. We do that by conducting assessments. We do that by leading investigations. But there's another piece as well around giving people the tools to do their jobs better and avoid these issues coming up in the first place.
I'm getting some questions from the floor. So I have one for Michael. You spoke of election offences. How quickly can you resolve an issue, particularly if an offence occurs days before an election? Isn't it too late by then?
Elections are really difficult for us. Like our volume of complaints in a typical year is ordinarily about 400 or 500. During the election period, we run at about 800 in that sort of 6 weeks period of the election. So, it is very difficult. Obviously, we have to triage and then prioritise the most serious of matters. So, if there's matters involving potential criminality that goes even beyond the election offences, as we've had in previous years, we may involve Victoria Police as well. So they've got greater capacity to deal with some of those potentially more serious offences. We're also looking at, in the past, we weren't able to proceed with people expeditiously because we had to produce, even if there's a breach of an offence, we had to produce a full brief of evidence and then go through the VTSO to get it assessed and then put it up to prosecute. Now we're seeking to get powers to actually issue penalty notices for some of these sort of strict liability offences, so we can actually move quicker and be seen to be moving quicker.
It's not one of the difficulties, particularly leading into election, about the decision whether to intervene either privately or publicly on a complaint because of the impact that may well have on the election. So you've got some really difficult decisions, and we don't, fortunately, because most candidates are not captured by our jurisdiction in the lead up. So Michael has perhaps the more difficult decision about what to do publicly or privately with a complaint and what effect that might have on the election process, and whether to intervene or not and deal with it after the election are some really complex matters you've got to wrestle with.
Yeah, it's a good point, but we don't do it in isolation. We work really closely with the Electoral Commission as well. So, we tend to look at matters may be reported to them in the first instance and they send them across to us, or there'll be some where we're not quite sure where it rests, if it's something that's a procedural thing that's best VEC deals with it. But we work really close with them. So we're not going to make any decision, I hope, that in any way interferes with the VEC's sort of smooth administration of the running of the election. So, but yeah, there are difficulties around, taking action that it's seen to be favouring or disfavouring any particular candidate. So we have to be conscious of it.
I've got a question for you, Andrew, and it's about witness welfare. What steps do you take to protect a witness?
So look, there are a number of things, and I guess it depends on the scenario, the particular instance the particular vulnerabilities that a person might be presenting with, but it's something that we're very conscious of at all elements of when we're engaging with either members of the public or members of the sector as well. It is certainly front and centre of mind for us. In the context of maybe a PIC or a PID, it's important to note, I think, that the disclosure and the subject of the allegations may have welfare concerns that arise. We appreciate that it is no small thing to be asked to appear before the Ombudsman to give evidence, whether you're giving evidence as a witness or as the subject of an allegation that's been made about you. We appreciate that. Connecting people with EAP type services to ensure that they have the support that they need. Engaging quite closely with the Public Interest Disclosure Coordinator and Welfare Coordinator within the agency itself, recognising that often these are council staff that might be involved in these processes, and there are employer-employee obligations to ensure the welfare of their staff, and enabling the council or the agency to do that is quite important. There's a strong element of keeping people informed as well about the process and where it's going, managing expectations, and allowing them to seek the assistance, the best assistance that they need for their particular circumstances.
There's a question that I'll put more broadly. In the existence of parallel offices or organisations, is there no possibility of functional interference and waste of time? I can see you're all jumping on that one.
Well, I'll jump in there quickly. It goes to something I said earlier. Sometimes it's not short. Like it is complex. Like my primary responsibility is like Government Act, but there's things in there with PIDs and PICs. There's a PID Act that covers that expressly. So we don't have that expertise. David's office is really the experts around that. So we need to get our heads together when anytime we get one of these scenarios to make sure that we're not potentially compromising the welfare or safety of a witness or complainant, even a subject. It's really, I wouldn't categorise that as a waste of time. It's a really important step that we understand who owns it, how the rest of the other agencies can deconflict from that, and to try and get the best outcome under the circumstances.
Well, I think this is to that point is exactly why the three agencies do meet so often to flesh out these issues, to ensure that right matters are going to the right place, the right tools are being used, because there are many ways to tackle a particular problem, whether it's an individual conduct issue, which is maybe a bit more prescriptive as to what the process will be, but the systemic issues could be raised as well, and we can all in our various ways respond to those. So being connected as best we can and allowing, as David described, it is a system. It is the integrity system that is made up of separate entities, but there is a strong sense of connectedness there.
Look, I would agree. Sometimes from the external perspective, it might seem complex, but hopefully we've demonstrated that it really isn't that complex, particularly when we're dealing with a matter and communicating amongst ourselves. I think it is appropriate that when you have an allegation that is quite serious of either corrupt or improper conduct, that it is dealt with appropriately. There is proper consideration of the elements of the complaint, and certainly considerations about the application of the public interest disclosure protections as well. It's not something that should be considered lightly. In doing that, there are things that we can do in parallel. We often talk about pieces of work that are underway whilst one of the other agencies might be still dealing with the matter. We can give advance indication about what we might be wanting to do. And we also talk often about resources. I talk to Michael often about, if we refer something over, have you got the capacity to actually deal with it, or do we look at another option? So I think all those things, when you take into account in terms of a system that operates and protecting either complainants and complaints, I think it's really important that we deliver those functions.
This is a question for you, Andrew, and potentially for me as well. Councils are experiencing a significant increase in aggressive behaviour towards our staff and community members. How is the Ombudsman protecting council staff and ensuring their safety during investigations?
So when we're investigating council staff, look, I think our staff experience the challenges that can come with public-facing roles on a day-to-day basis as well. So I'd say, there is a strong amount of empathy and understanding in that respect, just how hard it can be engaging with the community that might be particularly heightened over a particular issue or have additional needs that are challenging, that we can find really quite challenging to respond to. I think that there needs to be, what we do for our staff is ensure that there are internal support mechanisms in place to assist staff that are on the phones and dealing with those challenging matters, challenging calls, have the ability after a proper process and proper consideration of human rights, that you might need to limit somebody's access to your service and ensure that's obviously reviewable and proportionate to the circumstances. But yeah, I think as employers have OH&S obligations to their employees to provide a safe working environment, and it's on all of us to ensure that exists for our staff.
Well, I'm sure we could continue discussing this, and whilst it may not be the right image to leave people with, describing the three watchdogs as Cerberus, it's clear you're all joined at the hip when it comes to dealing with integrity issues in local government. But what I also hope is that we've demonstrated that there is a no wrong door approach when it comes to raising concerns, that the integrity agencies can also be flexible in their response. Final thanks go to Andrew Addison, our Assistant Ombudsman, Deputy Commissioner David Wolfe, and Chief Municipal Inspector Michael Stefanovic. Thanks also go to you for joining us today. A reminder to scan the QR code so you can respond to our feedback survey, and that a full recording of this webinar will be available on the Victorian Ombudsman website by the end of this week. Thank you for joining us, and see you next time.